What crime is committed by capatas who enrolls two fictitious names in the payroll and collects their supposed daily wages every day? 2017. The crime committed is estafa through falsification of public documents. A capatas is a foreman for the government, and since the falsification of the public document is committed as a means to commit estafa, the proper charge is estafa through falsification of documents. Domingo is the caretaker of 2 cows and 2 horses owned by Hannibal. Hannibal told Domingo to lend the cows to Tristan on the condition that the latter will give a goat to the former when the cows are returned. Instead, Tristan sold the cows and pocketed the money. Due to the neglect of Domingo, one of the horses was stolen. Knowing that he will be blamed for the loss, Domingo slaughtered the other horse, got the meat, and sold it to Pastor. He later reported to Hannibal that the 2 horses were stolen. What crime or crimes, if any, did Tristan commit? What crime or crimes, if any, were committed by Domingo? 2016. A. Tristan is liable for estafa through misappropriation under Article 315 of the Revised Penal Code. He received the cows under obligation involving the duty to return the same thing deposited, and acquired legal or juridical possession of so doing. Since their transaction is a comodatum, selling the cows as if he owned it constitutes misappropriation or conversion within the contemplation of Article 315. B. Domingo is liable for qualified theft under Article 308 of the Revised Penal Code. Although Tristan received the horse with the consent of the owner, Hannibal, his possession is merely physical or de facto, since the former is an employee of the latter. Slaughtering the horse which he physically possessed and selling its meat to Pastor shall be considered as taking without consent of the owner with intent to gain, which constitutes theft. Balerta versus People. Since the horse is accessible to him, the theft is qualified by the circumstance of abuse of confidence. Yonko versus People. Further, Domingo committed a crime of violation of the Anti-Cattle Rustling Law of 1974, PD 533. Cattle rustling is the taking away by any means, method, or scheme, without the consent of the owner or raiser of large cattle, which includes cows and horses, whether or not for profit or gain, or whether committed with or without violence against or intimidation of any person or force upon things. It includes the killing of large cattle, or taking its meat or hide without the consent of the owner or raiser. Which of the following acts does not constitute estafa or other forms of swindling? When a person wrongfully takes real property from its lawful possessor to the prejudice of the latter. Alternative answer: when a person disposes of the real property knowing it to be encumbered. What crime is committed by a person who, having found a ring, fails to deliver the same to the owner or to the local authorities? The finder commits theft. Who among the following is liable for estafa? The seller of a laptop computer who failed to inform the buyer that the laptop had a defect. Estafa under Article 318, Other Deceits, RPC, Ginhawa versus People. Alternative answer: the person who ran away with a cell phone which was handed to him upon his pretense that he had to make an emergency call. What crime is committed by one who, having received money, goods, or other personal property in trust or on commission or for administration, defrauds the offended party by denying receipt of such money, goods, or other property? He commits estafa with unfaithfulness or abuse of confidence. RR convinced WW to take a job in Taiwan, assuring her of a good salary and entitlement of a yearly vacation. WW paid RR the processing fee for passport and visa, but no receipt was issued for the payment. WW was made to use the alien certificate of registration of another person with a Chinese name and instructed on how to use the Chinese name. The application of WW was rejected by the Taiwanese authorities. Cases were filed against RR for illegal recruitment and estafa. The case of illegal recruitment was dismissed. Is RR liable for estafa? RR is liable for estafa made by means of false pretenses. With the intent to cause damage, AAA deliberately set fire upon the 2-story residential house of his employer, mostly made of wooden materials. The blaze spread and gutted down 7 neighboring houses. On the occasion of the fire, 6 persons sustained burn injuries which were the direct cause of their death. What crime was committed by AAA? AAA committed simple arson. What crime is committed by a utility worker in government who destroys office files as an act of revenge against his supervisor? The utility worker commits malicious mischief. Is the crime of theft committed by a person who, with intent to gain, takes a worthless check belonging to another without the latter's consent? No, the taking of the worthless check, which has no value, would not amount to the crime of theft because of the legal impossibility to commit the intended crime. Jacinto versus People, July 13, 2009. Isabella, housemaid, broke into a pawn shop intent on stealing items of jewelry in it. She found, however, that the jewelry were in a locked chest. Unable to open it, she took the chest out of the shop. What crime did she commit? Robbery in an inhabited place or in a private building. There is violation of Article 316 RPC, other forms of swindling, where the owner disposes of his encumbered real property as if it is free from encumbrances. Any person who, having found lost property, shall fail to deliver the same to the local authorities or its owner is liable for theft. X draws a check upon request of Y, the payee, who told X that he would merely show the check to his creditor to gain more time to pay his account. The check bounced upon presentation by the creditor. Under the circumstances, who can be prosecuted for estafa based on the dishonored check? Y, as the one who negotiated the check contrary to the agreement. Removing, concealing, or destroying documents to defraud another constitute the crime of estafa if committed by private individuals. Which of the following circumstances of dishonor of a check can be a basis for prosecution under the bouncing checks law? The check, drawn and issued in the Philippines, was dishonored by the Joey Bank in a foreign country. X and his stepfather have a long-standing enmity. One day, irked by an argument with his stepfather, X smashed the windshield of his stepfather's brand-new Audi sports car. X is liable for malicious mischief. A, B, and C agreed to rob the house of Mr. D at 10 o'clock in the evening, with C as the driver of the tricycle which they would use in going to and leaving the house of Mr. D, and A and B as the ones who would enter the house to get the valuables of Mr. D as planned. C parked the tricycle in a dark place, while A and B entered the house through an open door. Once inside, A entered the master's bedroom and started getting all the valuables he could see, while B entered another room. While inside the room, B saw a male person and immediately B brought out his gun, but he accidentally pulled its trigger. The bullet went through the window, hitting a neighbor that killed him. Neighbors were then awakened by the gunfire, and policemen were alerted. Not long after, policemen arrived. A and B panicked and got hold of a young boy and shouted to the policemen who were already outside of the house that they would harm the boy if the policemen did not disperse. A and B demanded that they should be allowed to use a vehicle to bring them to a certain place, and that would be the time that they would release the young boy. The policeman acceded. In the meantime, C was arrested by the policeman while he was about to flee, while A and B, after releasing the young boy, were arrested. What crimes did A and B and C commit, and what modifying circumstances attended the commission of the crime? 2014. A, B, and C committed the crime of robbery with homicide under Article 294, Number 1 of the RPC. It is immaterial that the death of the person occurred by mere accident as long as homicide is produced by reason or on occasion of the robbery. The crime is robbery with homicide, as it is only the result, without reference or distinction as to the circumstances, causes, modes, or persons intervening in the commission of the crime that has to be taken into consideration. They are not liable for the detention of the boy, as illegal detention is absorbed by the crime of robbery. The modifying circumstance of dwelling attended by commission of the crime. The settled rule is that dwelling is aggravating in robbery with homicide. Madam X, a bank teller, received from depositor Madam Y a check payable to cash in the amount of 1 million to be deposited to the account of Madam Y. Because the check was not a cross check, Madam X credited the amount to the account of her good friend, Madam W, by accomplishing a deposit slip. 7 days after, Madam X contacted her good friend, Madam W, and told her that the amount of 1 million was wrongfully credited to Madam W. Thus, Madam X urged Madam W to withdraw the amount of 1 million from her account to turn over the same to Madame X as a dutiful friend. Madame W readily acceded. She was gifted by Madame X with an expensive Hermes bag after the withdrawal of the amount. What crimes, if any, did Madame X and Madame W commit? Madame X shall be liable as principal in the crime of qualified theft committed with a grave abuse of confidence defined and punished under Article 310 of the RPC. Being a bank teller, she had only the physical possession, not juridical possession of the money received by her. Consequently, her subsequent misappropriation of the same shall constitute the crime of theft qualified with grave abuse of confidence. Madame W is not criminally liable. She had no knowledge of the crime and withdrew the money from her account and turned over the same to Madame X because of the misrepresentation of the latter that the 1 million was wrongfully deposited to her account. Her participation is not based on conspiracy or community of design, without which she cannot be held liable as principal by direct participation, principal by dispensable cooperation, or accomplice. Receiving an expensive Hermes bag from Madame X will not make Madame W liable as an accessory, since the latter has no actual knowledge of the commission of the crime or theft by the former, and the bag cannot be considered as the effects of the crime, since there is no showing that the money withdrawn was used in buying it. Klepto went alone to a high-end busy shop and decided to take one of the smaller purses without paying for it. Overcome by the conscience, she decided to leave her own purse in place of one she took. Her act was discovered and Klepto was charged with theft. She claimed that there was no theft, as the store suffered no injury or prejudice because she had left a purse in place of the one she took. Comment on her defense. Her defense is untenable. Theft was already consummated from the taking of personal property of another with intent to gain without the consent of the latter. The presence of injury or damage is not an element of theft. Her leaving behind her own purse will not alter the fact that she took a purse from the high-end shop without the consent of the owner. Is the crime of theft susceptible of commission in the frustrated stage? Explain. No, unlawful taking is deemed complete from the moment the offender gains possession of the thing, even if he has no opportunity to dispose of the same. Unlawful taking, which is the deprivation of one's personal property, is the element which produces the felony in its consummated stage. At the same time, without unlawful taking as an act of execution, the offense could only be attempted theft, if at all. Thus, the theft cannot have a frustrated stage. Theft can only be attempted or consummated. Valenzuela versus People. Mr. Benji is the owner of a hardware store specializing in the sale of plumbing materials. On February 1, 2014, Mr. Ed, a friend and regular customer of Mr. Benji, visited the hardware store and purchased several plumbing materials in the total amount of 5 million. Mr. Benji readily accepted Mr. Ed's payment of 3 post-dated checks in the amount of 1 million pesos each in view of the assurance of Mr. Ed that the checks will be honored upon presentment for payment. Mr. Benji, as a consequence, immediately delivered the materials to the house of Mr. Ed. The following day, Mr. Ed went back to Mr. Benji to tender another 2 post-dated checks in the amount of 1 million each to complete the payment, with the same assurance that the checks will be honored upon presentment for payment. When the checks were presented for payment, all were dishonored for insufficiency of funds, and corresponding notices of dishonor were sent and received by Mr. Ed. 1 month after receipt of the notice of dishonor, Mr. Ed failed to make good the payment checks. Thereafter, Mr. Benji filed before the Public Prosecutor's Office a complaint against Mr. Ed, although no demand letter was earlier sent to Mr. Ed. During the preliminary investigation, Mr. Benji accepted several amounts from Mr. Ed's partial payments. The wife of Mr. Benji protested and insisted that the complaint should continue despite the partial payments. On the other hand, Mr. Ed counters that no demand letter was earlier sent to him, that the obligation is merely civil in character, and that novation took place when Mr. Benji accepted the partial payments. Discussed the criminal liability. Mr. Ed is liable for 1 count of estafa under Article 315, Number 2, Letter D, for the issuance of the first 3 checks, because he issued them simultaneous The wife of AAA predeceased his mother-in-law. AAA was accused of defrauding his mother-in-law under criminal information for estafa, but the actual recital of facts of the offense charged therein, if proven, would constitute not only the crime of estafa but also falsification of public document as a necessary means for committing estafa. AAA invokes the absolutory cause of relationship by affinity. Which statement is most accurate? Considering that under the given situation, the two crimes of estafa and falsification of public documents are not separate crimes but component crimes of the single complex crime of estafa and falsification of public document, the absolutory cause of relationship by affinity is not available to AAA. Interstate Estate of Manolito Gonzalez de Corongcong versus People. Anthony drew a promissory note and asked his terminally ill and dying business partner Ben to sign it. The promissory note bound Ben to pay Anthony 1 million pesos plus 12% interest on or before June 30, 2011. If Ben died before the promissory note's due date and Anthony still collected 1 million with interest from Ben's estate, what crimes did Anthony commit? Estafa. On June 1, 2011, Efren bought a used top-of-the-line Mercedes-Benz for 7.5 million from Sweetic Trading. On the same day, he paid 2.5 million in cash and issued Sweetic Trading a check for 5 million, dated July 31, 2011. He then brought the car to the friend's house and hid it in an underground garage. The check Efren issued was dishonored for insufficiency of funds when presented for payment on due date. Efren was asked to honor and pay the check or to return the car, but he refused. What crime or crimes did Efren commit 2013? Estafa and a violation of BP 22. Frank borrowed 1 million from his brother Eric to pay the loan. Frank issued a post-dated check to be presented for payment on a month after the transaction. 2 days before maturity, Frank called Eric telling him he had insufficient funds and requested that the deposit of the check be deferred. Nevertheless, Eric deposited the check and it was dishonored. When Frank failed to pay despite demand, Eric filed a complaint against him for a violation of BP 22, 2013. Was the charge brought against Frank correct? Yes, the charge brought against Frank is correct. Violation of BP 22 is malum prohibitum, which is committed by mere issuance of a check. Good faith is not a defense. As long as the check was issued on account or for value, the purpose for which the check was issued, the terms and conditions relating to the issuance are irrelevant to the prosecution of the offender. For this reason, the request of Frank to defer the payment of the check, as it has insufficient funds, will not militate against his prosecution for BP 22, despite notice. Frank can still be charged. Moreover, if what is charged is estafa, Frank, being a brother of the offended party, cannot be held criminally liable under Article 332 RPC. What crime is committed by one who defrauds another by taking undue advantage of the signature of the offended party in a blank check, and by writing the payee and the amount of the check to the prejudice of the offended party? Estafa with unfaithfulness or abuse of confidence. Dora gave Ellen several pieces of jewelry for sale on commission basis. They agreed that Ellen would remit the proceeds of the sale and return the unsold items to Dora within 60 days. The period expired without Ellen remitting the proceeds of the sale or returning the pieces of jewelry. Dora demanded by phone that Ellen turn over the proceeds of the sale and return the unsold pieces of jewelry. Ellen promised to do so. The following day, Ellen still failed to make good on her promise, but instead issued post-dated checks. Thereafter, Dora made several more demands, the last of which was in writing, but they were all unheeded. When the checks were deposited in Dora's bank account, the checks were returned unpaid for insufficient funds. Ellen was charged with estafa in violation of BP 22. Will the charge against Ellen prosper? Article 315, paragraph 1, letter B of the RPC punishes estafa through misappropriation. To prove the foregoing crime, the prosecution must establish the following elements: the offender's receipt of money, goods, or other personal property in trust, or in commission, or for administration, or under any other obligation involving the duty to deliver or to return the same. 2. Misappropriation or conversion by the offender of the money or property received, or denial of receipt of the money or property. 3. The misappropriation, conversion, or denial is to the prejudice of another. And 4. Demand by the offended party that the offender return the money or property received. In the case at hand, the pieces of jewelry were received by Ellen from Dora. an act which transferred the juridical possession of the former. To have juridical possession means possession which gives the transferee a right over the thing which the transferee may set up against the owner. Generally, demand for the return of the thing delivered in trust is necessary before an accused is convicted of estafa. However, if there is an agreed period for the return of the thing received in trust and the accused failed to return it within the agreed period, demand is unnecessary. Failure to return the thing within the agreed period consummates the crime of estafa. The misappropriation of the thing received in trust. In this case, Dora and Ellen agreed on a period within 60 days for the delivery of the proceeds of the sale and return of the unsold items to Dora. Ellen's failure to return within 60 days is a presumption of misappropriation of jewelry. Thus, there would be no more need to present any act of misappropriation. Della convinced Nita to work in Taiwan, promising Nita that she would take care of the processing of the necessary documents. Della collected $120,000 from Nita, purportedly for the processing of her papers. Upon receipt of the money, Nita was made to accomplish certain forms and was told that she would be deployed to Taiwan within 1 month. After 1 month, Nita followed up on her application. Della made some excuses and told Nita that the deployment would be delayed. Another month passed and Della made another excuse which made Nita suspicious. Nita later discovered that Della was not licensed to recruit. Nita confronted Della and demanded the return of her money. Della promised to return the same in a week's time, 2015. A week later, Della was nowhere to be found. What crime did Della commit? Della defrauded Nita by leading her to believe that she has the capacity to send her to Taiwan for work, even though she does not have a license or authority for the purpose. Such misrepresentation came before Nita gave Della $120,000 for the processing of her papers. Clearly, Nita would have not parted with her money were it not for such enticement by Della. As a consequence of Della's false pretenses, Nita suffered damages as the promised employment abroad never materialized and the money she paid was never recovered. Thus, the crime of estafa through falsification of public document is committed. Since Della has no license to recruit, the crime of illegal recruitment is also committed. People vs. Chua. Will your answer be the same, assuming that the promise to deploy for employment abroad was made to Della by Celia, Digna, and Emma, in addition to Nita, and from whom Della also collected the same amount of processing? Yes. Della shall be liable for both estafa under paragraph 2, letter A of Article 315 of the RPC and illegal recruitment, but in large scale. Illegal recruitment is deemed committed in large scale if committed against 3 or more persons individually or as a group. Since there are at least 3 victims in this case, Celia, Digna, Emma, and Nita, Della shall be liable for large-scale illegal recruitment under the earlier cited provision, People vs. Tolentino. AA misrepresented to the complainant that he had the power, influence, authority, and business to obtain overseas employment upon payment of placement fee. AA duly collected the placement fee from complainant. As per certification of the Philippine Overseas Employment Administration, AA did not possess any authority or license for overseas employment. Is it proper to file 2 separate information for illegal recruitment under Labor Code and for estafa for means of deceit? Yes, a person convicted for illegal recruitment under the Labor Code may, for the same act, be separately convicted of estafa by means of deceit. Bruno, a taxi driver, had an indebtedness in the sum of $10,000, which would become due in 1 week. He was starting to worry because he still had not raised the money to pay for his debt. Every day he had prayed for divine intervention. One night, while returning the taxi to the garage, he found a wallet on the back seat. Inspecting it, he learned that it contained exactly $10,000 cash, the amount of his obligation, and IDs. Thinking it was divine intervention and that his prayers were answered, he took the money and used it to pay his debt. 2015. What crime, if any, did Bruno commit? Bruno committed the crime of theft. The owner is known to Bruno because there are IDs found in the wallet. Failure to deliver to the local authorities or to its owner the lost property which he found constitutes theft under Article 308 of the Revised Penal Code. Assuming that instead of using the money, Bruno turned over the wallet and its contents to the nearby police station, and it was the chief of police of that station who appropriated the money for his own benefit, what crime was committed by the chief of police? The chief of police is liable for theft. Although he is not the one who found the property, he is considered as finder in fact, since the property was surrendered to him by the actual finder. He acquired the position occupied by the actual finder and assumed by voluntary substitution the obligation to surrender the property to the lawful owner. Appropriating the property is of the same character of that made by one who originally found the same. People versus Avilia. The liability of the finder, in fact, is the same liability of the finder in law. Thus, what the chief of police committed is theft. True or false? A person who, on the occasion of a robbery, kills a bystander by accident is liable for two separate crimes, robbery and reckless imprudence resulting in homicide. False. Only one crime of robbery with homicide is constituted because the revised penal code punishes the crimes as only one indivisible offense when a killing, whether intentional or accidental, was committed by reason or on occasion of a robbery. Article 294. On her way home, Eva Marie saw an injured chow chow puppy behind a bush. Since the puppy did not have a collar, she brought it home so she could have it as a pet. Her son, in fact, begged Eva Marie to keep the puppy. The following day, Eva Marie bought a collar for the puppy and brought it to a veterinarian for treatment. Did Eva Marie incur criminal liability in bringing the puppy home as a pet? Yes. Eva Marie incurred criminal liability for the crime of simple theft. The puppy is personal property which is susceptible of taking and has pecuniary value. Obviously, she took it with intent to own it, hence with intent to gain. Did she incur civil liability? Eva Marie may incur civil liability if the owner of the puppy would incur a loss due to non-restitution or return thereof to the owner. Finding any property of value, legally regarded as lost property, would constitute theft if the finder failed to deliver the same to the local authorities or its owner. 308 paragraph 1. Once Eva Marie is found guilty of theft, she will incur civil liability which consists of restitution or reparation for damage caused and indemnification for consequential damages. Article 100 RPC. The general rule is a person who is criminally liable is also civilly liable. Paul lives with his longtime girlfriend, Joanne, in a condominium in Makati. For more than a year, she has been secretly saving money in an envelope under their bed to buy her an engagement ring. One day, while Joanne was cleaning their room, she found the envelope, took the money, and left Paul. As prosecutor, what crime, if any, would you charge Joanne? Joanne may be charged with qualified theft because she took away personal property belonging to Paul without the latter's consent, so obviously with intent to gain and with grave abuse of confidence. But Joanne may invoke as defense Article 332 of the revised penal code, under which no criminal liability but only civil liability shall result from the crime of theft, swindling, or malicious mischief committed by spouses, among others. The reference to theft under article embraces both simple theft and qualified theft, and the reference to spouses includes common law or live-in relationship. People versus Constantino. Christopher, John, Richard, and Luke are fraternity brothers. To protect themselves from rival fraternities, they all carry guns whenever they go. One night, after attending a party, they boarded a taxi cab, held the driver at gunpoint, and took the latter's earning. What crime, if any, did the four commit? The crime committed is robbery by a band, since there were four of them, offenders acting in concert in committing the robbery, and all the four were armed. The elements of this crime are: 1. Unlawful taking of personal property belonging to another, the earning of the taxi driver. 2. Intent to gain in the taking of the earnings which belong to the taxi driver. Violence against or intimidation of person or force upon things was employed in the taking. And 4. That there were more than 3 armed malefactors taking part in the commission of the robbery. Article 296 in relation to Article 294 Revised Penal Code. Who are brigands? Distinguish brigandage from robbery in band as to elements, purpose of the offender, and agreement among the offenders. When more than 3 armed persons form a band of robbers for the purpose of committing robbery in the highway, or kidnapping persons for the purpose of extortion, or to obtain ransom, or any other purpose to be attained by means of force and violence, they shall be deemed highway robbers or brigands. The following distinction between brigandage and robbery by band. Brigandage. Elements. There are at least 4 persons. They form a band of robbers. Purpose: to commit robbery in highway, kidnap or extort or get ransom. Any other purpose to be achieved by means of force or violence. Agreement: the agreement among more than 3 armed men is to commit robbery in the highway. Robbery in band: more than 3 armed malefactors take part in the commission of a robbery. Purpose: commit robbery, but not necessarily in highway. agreement. The agreement is to commit only a particular robbery. What is the criminal liability of a person who knowingly and in any manner aids or protects highway robbers or brigands by giving them information about the movement of the police? He is criminally liable as principal for aiding and abetting a band of brigands. Alternative answer: he is criminally liable as an accomplice of the principal offenders. Senyo planned to burn Bal's house. One evening during a drinking spree at his house, Senyo told his friends what he intended to do and even showed them the gasoline in cans that he would use for the purpose. Carlo, a common friend of Senyo and Bal, was present at the drinking spree. He was still sober when Senyo told them his plans. Before going home, Carlo warned Bal that Senyo would burn his house and had already bought gasoline that would be used for the purpose. Bal reported the matter to the police authorities. Meanwhile, Senyo went to Bal's house and proceeded to pour gasoline around the walls of the house, and it was at that point when he was caught by the police. What crime did Senyo commit, if any? 2015. Senyo is liable for attempted arson. He manifested before his intention to burn the house of Bal to his friends. He then performed the act of pouring gasoline around the walls of the house to execute his criminal design to commit arson. This is not just a preparatory act, because it already ceased to be equivocal and revealed a clear intention to burn the house. In sum, he already commenced the commission of the crime of arson directly by overt acts, but he did not perform all acts to execute his criminal design to commit arson by setting the house on fire due to the cause other than his spontaneous desistance, and that is having been caught by the police. Alternative answer: the crime could only be malicious mischief, as the problem does not mention that he is carrying a match or a lighter. It was not shown that Senyo was about to light a match or ignite a lighter to set the house on fire. Ophelia, engaged in the purchase and sale of jewelry, was charged with violation of PD 1612, otherwise known as the anti-fencing law, for having been found in possession of recently stolen jewelry valued at $100,000 at her jewelry shop. Her defense is that she merely bought the same from Antonia and produced a receipt covering the sale. She presented other receipts given to her by Antonia, representing previous transactions. Convicted of the charge, Ophelia appealed, arguing that her acquisition of the jewelries resulted from a illegal transaction and that the prosecution failed to prove that she knew or should have known that the pieces of jewelry which she bought from Antonia were proceeds of the crime of theft. What is offense under PD 1612? Is Ophelia liable under anti-fencing law? Explain. 2016. Fencing is the act of any person who, with intent to gain for himself or for another, shall buy, receive, possess, keep, acquire, conceal, sell, or dispose of, or shall buy and sell or in any other manner deal with any article, item, object, or anything of value, which he knows or should be known to him to have been derived from the proceeds of the crime of robbery or theft. B. No, Ophelia is not liable under the anti-fencing law. While under the said law, mere possession of any good, article, item, object, or anything of value which has been the subject of robbery or thievery shall be prima facie evidence of fencing. Such evidence, when sufficiently overturned, constitutes a defense. In this case, Ophelia's defense that she merely acquired the jewelry through a legitimate transaction is sufficient. Further, there is no other circumstances as regard the jewelries which would indicate to Ophelia, an innocent purchaser, that the jewelries were the subject of theft. There was even a receipt produced by Ophelia of the transaction. Alternative answer, letter B, yes. Under Section 5 PD 1612, mere possession of any good, article, item, object, or anything of value which has been the subject of robbery or thievery shall be prima facie evidence of fencing. Failure to prove that Ophelia knows or should have known that the jewelry is stolen, therefore, is not a defense, since this element is presumed to be present under Section 5 because Ophelia is in possession of this stolen property. Moreover, there is no showing that Ophelia secured a permit or clearance from the PNP station commander of the place of sale required in Section 6, PD 1612. Suggested answer by UP Law Center to a 1995 bar question. Alternative answer. No, although Ophelia as a possessor of a stolen property is presumed to have committed the crime of fencing, such presumption is overcome by presentation of the receipts showing that the transaction is legitimate. The logical inference follows that Ophelia had no reason to suspect that the jewelry was stolen. Admittedly, there is no jurisprudence to the effect that the receipt is a sufficient defense against charges of fencing, but logically and for all practical purposes, such receipt is proof, although disputable. that the transaction in question is above board and legitimate. Absent other evidence, the presumption of innocence remains. D.M. Consunji versus Isguera. Manolo, an avid art collector, was invited to Tonio's house. There, Manolo noticed a nice painting that exactly looked like the painting which he reported was stolen from him some years back. Manolo confronted Tonio about the painting, but Tonio denied any knowledge. Claiming that he bought the painting legitimately from a friend, Manolo later proved to Tonio that the painting was indeed the stolen painting. What crime, if any, may Tonio be charged with? Tonio may be charged with the crime of fencing under Section 5 PD 1612. Mere possession of a stolen article of object of anything of value which has been the subject of a robbery or thievery is the prima facie evidence of fencing. Since Tonio is in possession of the stolen property, it is presumed that he committed the crime of fencing. Manolo decided to take matters into his own hands. One night, broke into Tonio's house by destroying the wall and taking the painting. What, if any, would be the liability of Manolo? Manolo is liable for the crime of trespass to dwelling qualified by use of force, since he entered the house of Tonio against the latter's will. There is no robbery because the owner of the property taken cannot commit robbery. Roberto bought a Toyota Fortuner from Inigo for 500,000. While driving his newly bought car, Roberto made a minor accident that made the examination of his vehicle's registration certificate necessary. When the policeman checked the plate, chassis, and motor numbers of the vehicle against those reflected in the registration certificate, he found the chassis number to be different from what the registration certificate stated. The deed of sale covering the sale of the Fortuner signed by Inigo also bore the same chassis number as Roberto's registration certificate. The chassis and motor numbers on the Fortuner were found upon verification with the Land Transportation Office to correspond to a vehicle previously reported as carnap. Roberto claimed that he was in good faith. Inigo sold him a carnap vehicle, and he did not know that he was buying a carnap vehicle. If you were the prosecutor, would you or would you not charge Roberto? I will charge Roberto with violation of anti-fencing law. In this case, someone carnapped the vehicle, sold it to Roberto, who did not take part in the crime. Roberto should have known also that the car was stolen because it was not properly documented, as the deed of sale and registration certificate did not reflect the correct number of the vehicle's engine and chassis. Apparently, he made no effort to check the papers covering his purchase. Lastly, Roberto's defense of good faith is flawed because PD 1612 is a special law, and therefore its violation is regarded as malum prohibitum, requiring no proof of criminal intent. True or false? In the prosecution for fencing under PD 1612, is it complete defense for the accused to prove that he had no knowledge that the goods or articles found in his possession had been the subject of robbery? False. Fencing is committed if the accused should have known that the goods or articles had been the subject of theft or robbery. Mere possession of the stolen goods gives rise to the prima facie presumption of fencing. Fencing, how committed? Arlene is engaged in the buy and sell of used garments, more popularly known as ukay-ukay. Among the items found by the police in a raid of her store in Baguio City were brand new Louis Ferrod blazers. Arlene was charged with fencing. Would the charge prosper? No, a charge of fencing will not prosper. Fencing is committed when a person with intent to gain or for himself or for another deals in any manner with an article or value which he knows or should be known to him to have been derived from proceeds of theft or robbery. Thus, for a charge of fencing to prosper, it must first be established that theft or robbery of the article subject of the alleged fencing has been committed, a fact which is wanting in this case. It should be noted that the suspect is engaged in the buy and sell of used garments, which are in the nature of personal property. In civil law, possession of personal or movable property carries with it a prima facie presumption of ownership. The presumption of fencing arises only when the article or item involved is the subject of a robbery or thievery. 12. A Nigerian set up perfume business in the Philippines. The investors would buy the raw materials at a low price from Val. The raw materials consisted of powders, which the investors would mix with water and let stand until a gel was formed. Val made a written commitment to the investors that he would buy back the gel at a higher price, thus assuring the investors of a neat profit. When the amounts to be paid by Val to the investors reached millions of pesos, he sold all the equipment of his perfume business, absconded with the money, and is nowhere to be found. What crime or crimes were committed, if any? 2016. The crime committed is estafa through false pretenses. Article 315, paragraph 2, letter A. Val defrauded the investors by falsely pretending to possess business or imaginary transactions. The fact that he sold all the equipment of his perfume business and absconded with the money when the amounts to be paid by him to the investors reached millions of pesos shows that the transaction his business is imaginary and he defrauded the victims. A asked financial support from her showbiz friend B, who accommodated her by issuing in her favor a post-dated check in the sum of 90,000 pesos. Both of them knew that the check would not be honored because B's account has just been closed. The two then approached trader C, whom they asked to change the check with cash, even agreeing that the exchange be discounted at 85,000, with the assurance that the check shall be funded upon maturity. Upon C's presentment of the check for payment on due date, it was dishonored because the account has already been closed. What is C's remedy? A criminal action for a violation of BB 22 may be filed against B, who drew the post-dated check against a closed bank account for value paid by C, and with knowledge at the time he issued the check that the account thereof is already closed. A cannot be held liable under BB 22 because he was a mere endorser of B's check to C, who exchanged the check with cash. BB 22 does not apply to endorser of checks. Hence, only a civil action may be filed by C against A to recover the 85,000. Although a simultaneous action for estafa is authorized by law for the issuance of a worthless check, under the given facts, the check was discounted and thus issued in a credit transaction for a pre-existing indebtedness. Criminal liability for estafa does not arise when a check has been issued in payment for a pre-existing debt. The President, Treasurer, and Secretary of ABC Corporation were charged with syndicated estafa under the following information: that on or about the first week of January 2010 or subsequent thereto in Cebu City, and within the jurisdiction of this honorable court, the above named accused conspiring and confederating together, and all of them mutually helping and aiding one another in a syndicated manner, through a corporation registered with the Securities and Exchange Commission, with intention of carrying out an unlawful or illegal act, transaction, enterprise, or scheme with intent to gain, and by means of fraud and deceit, did it then and there willfully and lawfully and feloniously defraud Frina, Lana, Deborah, and several other persons by false or fraudulent transactions, which they made with complainants and the public in general, to the effect that they were in a legitimate business of foreign exchange trading successively or simultaneously operating under the name and style of ABC Corporation and DEF Management Philippines, Incorporated, induced and succeeded in inducing complainants and several other persons to give and deliver to said accused the amount of at least 20 million on the strength of said manifestations and representations. The accused knowingly well that the above named corporations registered with the SEC or SEC are not licensed or authorized to engage in foreign exchange trading, and that such manifestations and representations to transact in foreign exchange were false and fraudulent, that these resulted to the damage and prejudice of the complainants and other persons, and that the defraudation pertains to funds solicited from the public in general by such corporation or associations. Will the case of syndicated estafa prosper? No. A case for syndicated estafa will not prosper because a syndicate for such crime under PD 1689 must be comprised of 5 or more persons committing the estafa or other forms of swindling defined in Article 315 and 316 of the Revised Penal Code, whereas the case given involved only 3 accused who are alleged to have conspired in the commission of the swindling, but because the amount defrauded exceeds 100,000, the case is still under the same PD 1689 with a lower penalty than syndicated estafa. During the nationwide transport strike to protest the phase out of old public utility vehicles, striking jeepney drivers Percy, Pablo, Peter, and Sencho, each armed with guns, hailed several MMDA buses, then providing free transport to the stranded public to stop them from plying their routes. They later on commandeered one of the buses without allowing any of the passengers to alight, and told the driver to bring the bus to Tanay, Rizal. Upon reaching a remote area in Tanay, Percy, Pablo, Peter, and Sencho forcibly divested the passengers of their cash and valuables. They ordered the passengers to leave thereafter. Then they burned the bus. When a tanod of the barangay of the area came around to intervene, Peter fired at him, instantly killing him. After Percy, Pablo, Peter, and Sencho were arrested, the police authorities recommended them to be charged with the following crimes, to wit: carnapping, robbery, direct assault with homicide, kidnapping, and arson. State your legal opinion on the recommendation of the police authorities on the criminal liabilities 2017. Because Percy, Pablo, Peter, and Sencho commandeered the bus for purpose of robbing the passengers, the crime committed is robbery, People versus Moreno. Since the taking of the victims was merely to commit robbery and not to transport them to another place for purpose of detention, the crime committed was not kidnapping but robbery. People versus Puno. Criminal Law Conspectus by Florence Regalado. Intent to deprive liberty is not present, since the deprivation of liberty is just incidental to the commission of robbery. Since death results by reason or on occasion of robbery, the crime committed is special complex crime of robbery with homicide. A special complex crime of robbery with homicide. This composite crime is committed even though the victim of homicide is a responding barangay tanod, People versus Pelagio. Even though only Peter killed the tanod, Percy, Pablo, and Senyo are also liable for robbery with homicides since they failed to attempt to prevent the same. People versus De La Cruz. Since the crime committed is robbery with homicide, all other felonies such as arson and direct assault committed by reason or on occasion of robbery shall be integrated in the special complex crime of robbery with homicide. People versus Jugueta. Arson shall not be considered as a separate crime, but as a mere aggravating circumstance of commission of the felony by means of fire. U.S. versus Bulfa. The elements of carnapping are taking of the motor vehicle which belongs to another, b. the taking is without consent of the owner, or by means of violence against or intimidation of persons, or by using force upon things, c. the taking is done with intent to gain, People versus Bustinera. In this case, the accused unlawfully took the MMDA's bus without the consent of its owner, which gives rise to the presumption of their intent to gain. Considering that all elements of carnapping are present, the accused shall be liable therefor. Since carnapping is punishable under a special law, it shall be considered as a crime separate from robbery with homicide, People versus De La Cruz. A is the driver of B's Mercedes-Benz car. When B was on a trip to Paris, A used the car for a joyride with C, whom he is courting. Unfortunately, A met an accident. Upon his return, B came to know about the unauthorized use of the car and sued A for qualified theft. B alleged that A took and used the car with intent to gain, as he derived some benefit or satisfaction from its use. On the other hand, A argued that he has no intent of making himself the owner of the car, as he is, in fact, has returned it to the garage after the joyride. What crime or crime, if any, were committed? 2016. The crime committed by A is carnapping. The unlawful taking of motor vehicle is now covered by anti-carnapping law, RA 6539, and not by the provisions of qualified theft or robbery, People versus Bustinera. The concept of carnapping is the same as that of robbery and theft. Hence, rules applicable to theft or robbery are also applicable to carnapping, People versus Azamuddin. In theft, unlawful taking should be understood within the Spanish concept of apoderamiento. In order to constitute apoderamiento, the physical taking must be coupled with the intent to appropriate the object, which means intent to deprive the lawful owner of the thing, whether permanently or temporarily. People versus Valenzuela. In this case, A took the car without consent of B with intent to temporarily deprive him of the car, although the taking was temporary, and for a joyride, the Supreme Court in People versus Bustinera sustains as the better view that which holds that when a person, either with the object of going to a certain place or learning how to drive or enjoying a free ride, takes possession of a vehicle belonging to another without the consent of its owner, he is guilty of theft, because by taking possession of the personal property belonging to another and using it, his intent to gain is evident, since he derives therefrom utility, satisfaction, enjoyment, and pleasure. What should be the proper charge against the offender who unlawfully took and carried away a motor vehicle belonging to another without the latter's consent? Killing the driver in the process. The proper charge against the offender should be qualified carnapping or carnapping in an aggravated form. Using his charms because of his movie star looks, Phil is in a movie date with Lynn. A 19-year-old colegiala kissed her on the cheek and stroked her pubic hair. Lynn shouted for help and Phil was arrested. Phil is liable for acts of lasciviousness. Filipino citizens Hector and Wendy were married in New York and have been living happily in Manila for the last 3 years. Hector was removing junk from his basement when he came across an unlabeled record CD. He put it in his computer's DVD drive to check its content. To his surprise, he saw a video of Wendy and another man, Ariel, in the act of sexual intercourse in the master's bedroom of his house. Angered by what he saw, he filed a complaint of adultery against Wendy and Ariel. During the course of trial, and again, to the surprise of Hector, it was proved that Wendy was born male and underwent sex reassignment later in life. May Hector's charge of adultery against Wendy and April prosper? Yes, Hector's charge of adultery will prosper. Adultery has the following elements. The woman is married. She has sexual intercourse with a man not her husband. As regards the man with whom he has sexual intercourse, he must know her to be married. In the case at hand, the discovery by Hector of the video of Wendy having sexual intercourse with another man, Ariel, is sufficient to charge his wife with adultery. The fact that Wendy was later discovered by Hector to be born male, who simply underwent sexual reassignment later in life, is immaterial to the charge of adultery, considering that the marriage between the same sex is considered valid in the USA where they were married. What is an impossible crime? An impossible crime is an act which would be an offense against person or property were it not for the inherent impossibility of its accomplishment or on account of the employment of inadequate or ineffectual means. There is no impossible crime of adultery, since this is a crime against chastity and not against person or property. Loco advertised on the internet that he was looking for commercial models for a TV advertisement. Ganda, a 16-year-old beauty, applied for the project. Loco offered her a contract, which Ganda signed. She was asked to report to an address which turned out to be a high-end motel. Ganda became one of its famous featured attraction. What is Loco's liability, if any? What effect would Ganda's minority have on Loco's liability? Loco is liable of the crime of trafficking in persons under RA 9208. He recruited, offered, and hired Ganda by means of fraud or deception for the purpose of exploitation or prostitution. By means of deceit and the guise of making her commercial model, Loco recruited Ganda for the purpose of prostitution. Ganda's minority is a qualifying circumstance under Section 6 RA 9208. When the trafficked person is a child, the crime committed is qualified trafficking in person, penalized by life imprisonment. Illegal marriages. What are the elements of the crime of bigamy? If you were the judge in a bigamy case, where the defense was able to prove that the first marriage was null and void or a nullity, would you render a judgment of conviction or acquittal? Explain. 2012. The following are the elements of bigamy. 1. The offender has been legally married. 2. The marriage has not been legally dissolved, or in case of absence, the absent spouse would not yet be presumed dead according to NCC. 3. He contracted a second or subsequent marriage. And 4. The subsequent marriage has all the essential requisites for validity. Mercado versus Tan. If I were the judge, I will render judgment of conviction. Proof that the first marriage is null and void is not a defense in bigamy. As long as the previous marriage was not lawfully dissolved or judicially declared as null and void, contracting a new marriage constitutes bigamy. People versus Manuel. Assuming the existence of the first marriage when the accused contracted the second marriage and the subsequent judicial declaration of nullity of the second marriage on the ground of psychological incapacity, would you render a judgment of conviction or acquittal? 2012. I will render a judgment of conviction. A declaration of the nullity of the second marriage on the ground of psychological incapacity is absolutely of no moment insofar as the state's penal laws are concerned. Since the marriage contracted during the subsistence of a valid marriage is automatically void, the nullity of the second marriage is not per se an argument for the avoidance of criminal liability for bigamy. Although the judicial declaration of nullity of a marriage on the ground of psychological incapacity retroacts to the date of the celebration of marriage insofar as the vinculum between the spouses is concerned, it is significant to note that the said marriage is not without legal effects. Among these legal consequences is incurring criminal liability for bigamy. To hold otherwise would render the state's penal laws on bigamy completely nugatory, and allow individuals to deliberately ensure that each marital contract be flawed in some manner, and to thus escape the consequences of contracting multiple marriages, while beguiling throngs of hapless women with the promise of futurity and commitment. Tenebro versus CA. A, B, C, and D are members of the police department of a municipality. Conspiring with one another, they arrested E without reasonable ground for the purpose of delivering him to the proper authorities by imputing to E the crime of bribery. While E was being investigated by A, B, and C and D, one of them placed a marked 500 peso bill, together with the money taken from E, to make it appear that E, an employee of the office of the local civil registrar, agreed to perform an act not constituting a crime in connection with the performance of E's duties, which was to expedite the issuance of a birth certificate. What is the crime committed by A, B, C, and D? A, B, C, and D committed incriminatory machination through unlawful arrest. Plaintiff X, in his civil complaint for damages, the defendant Y, employing fraud, convinced him to buy a defective vehicle. Y filed a criminal action for libel against X for maliciously imputing fraud on him. Will the action prosper if it turns out that the civil complaint for damages was baseless? No, since pleadings filed in court are absolutely privileged. X, a tabloid columnist, wrote an article describing Y, a public official, as stupid, corrupt, and having amassed ill-gotten wealth. X relied on a source from Y's own office who fed him the information. Did X commit libel? Yes, since the article was libelous and inconsistent with good faith and reasonable care. The exchanges of highly offensive words between two quarreling women in the presence of a crowd of people constitute two separate counts of light slander, one for each woman. X, a court employee, wrote the presiding judge a letter imputing to Y, also a court employee, the act of receiving an expensive gift from one of the parties in a pending case. Because of this, Y accused X of libel. Does Y need to prove the element of malice in the case? Yes, malice is not presumed since X wrote the letter to the presiding judge, who has a duty to act on what it states. Sam wrote a letter to his friend stating that Judge Odon loves obscene magazines and keeps these in his desk. Charged with libel, can Sam present proof that Judge Odon indeed loves obscene magazines and keeps these in his desk? No, since Sam does not impute a crime to Judge Odon. In her weekly gossip column in the tabloid, Gigi wrote an unflattering article about Pablo, a famous singer, and his bitter separation from his wife. The article portrayed Pablo as an abusive husband and caused him to lose lucrative endorsement contracts. Pablo charged Gigi with libel. In her defense, Gigi countered that she did not commit libel because Pablo has attained the status of a public figure, so that even his personal life has become a legitimate subject of public interest and comment. Is Gigi correct? 2013. No, Gigi is not correct. Although wider latitude is given to defamatory utterances against public figures in relation to matters of public interest involving them, such defamatory utterances do not automatically fall within the ambit of constitutionally protected speech. If the utterances are false, malicious, or unrelated to a public figure's work, the same may give rise to a criminal liability. Fermin versus People. Any attack upon the private character of the public figure on matters which are not related to their works may constitute libel under Article 355. Sasson versus CA. Here, Gigi was attacking the personal life of Pablo as a husband and not his public life as a famous singer. In his answer to a complaint, Attorney Jose, counsel for the defendant, stated that Attorney Agranda, counsel for the plaintiff, is bobo, inútil, good for nothing, stupid, and a menace to clients. Can attorney Jose be held criminally liable for libel? Yes, although a court pleading is a privileged communication, malicious statements that are irrelevant and impertinent to the issue in the pleading may be libelous. True or false? In the crime of libel, truth is an absolute defense. False. Article 361 of the RPC provides that proof of truth shall be admissible in libel cases only if the same imputes a crime or is made against a public officer with respect to facts related to the discharge of their official duties, and moreover must have been published with good motives and for justifiable ends. Hence, truth as a defense on its own is not enough. Angeline maintains a website where visitors can give their comments on the posted pictures of the goods she sells in her exclusive boutique. Bettina posted a comment that the red Birkin bag shown in Angelina's website is fake and that Angelina is known to sell counterfeit items. Angelina wants to file a case against Bettina. She seeks your advice. What advice will you give her? I will advise Angelina to file a criminal case of libel against Bettina because the imputations made by Bettina is libelous. Whether the imputation of a defect, status, or condition is real or imaginary, if it publicly tends to discredit, dishonor, or place in contempt, or ridicule a particular person who is identified, the imputation is presumed by law to be malicious and thus penalized as libel under Article 355 of the Revised Penal Code. Moreover, if Bettina is engaged in similar line of trade, her statement against the goods sold by Angelina may constitute a violation of the law on unfair competition. Republic Act No. 8291. Criminal Negligence, Article 365. AB was driving a van along a highway. Because of her recklessness, the van hit a car which had already entered the intersection. As a result, CD, who was driving the car, suffered physical injuries, while damage to his car amounted to $8,500. What is the proper charge against AB? AB should be charged with reckless imprudence resulting in slight physical injuries and reckless imprudence resulting in damage to property. Note: the Supreme Court in Ivler v. Modesto San Pedro rules that reckless imprudence under Article 365 is a single quasi-offense by itself and not merely a means to commit other crimes. Hence, conviction or acquittal of such quasi-offense bars subsequent prosecution for the same quasi-offense, regardless of its various consequences. The law penalizes, thus, the negligent or careless act, not the result thereof. And as the careless act is single, whether the injury's result should affect one person or several persons, the offense criminal negligence remains one and the same and cannot be split into different crimes in prosecution. After drinking a bottle of Jack Daniels, John drove his BMW sports car at high speed, rammed into a group of crossing pedestrians, and hit a traffic light post. The incident caused the death of one pedestrian, serious injuries to 3 others, and the destruction of the traffic light post. If you were the prosecutor, what would you charge John? Reckless imprudence resulting in homicide, serious physical injuries, and damage to property. A crime resulting from negligence, reckless imprudence, lack of foresight, or lack of skill is called culpa. Culpa can either be a crime by itself or a mode of committing a crime. Culpa is a crime by itself in medical malpractice.